Hello, I'm Stacey Christensen from the Information Policy Analysis Division, or IPAD. We're a division within the Minnesota Department of Administration. I'll be discussing Minnesota Statutes, Chapter 13D, which details some of the requirements that public bodies, such as school boards, city councils, and county boards, must follow in conducting their meetings. This law is called the Open Meeting Law. There are some exceptions, but the law generally requires all meetings of public bodies to be open to the public. This means that the public, including the media, can attend these meetings. It is important for the public to remember that although they can attend open meetings under the law is silent on whether or not people can speak at a meeting. I've mentioned that the law's requirements apply to public bodies. A frequent question we hear is, what exactly is a public body? The phrase public body is not defined in the open meeting law, but the law does list certain entities which must have open meetings. Some of these include state-level entities, such as state agencies, boards, and commissions, local entities, such as school boards, city councils, county boards, and water conservation districts, and any committees or subcommittees of a state or local public body. People often ask whether the open meeting law applies when less than a majority of a public body's members meet together. You won't find the answer to this question in the law, but the Minnesota Supreme Court provided some guidance in what is commonly known as the quorum rule. A quorum is a majority of a public body's members. The quorum rule has two parts. A public body's meetings are subject to the open meeting law if 1. There is a majority or more of the full public body or a majority of any of its committees, subcommittees, boards, commissions, etc. And 2, the majority discusses, decides, or receives information as a group on issues relating to its official business. The Minnesota Supreme Court also said that the law doesn't necessarily apply to chance or social gatherings, such as banquets or parties. The court interpreted the law to mean that even if there is a quorum at a social gathering, it is not a meeting under the law unless the quorum discusses or receives any official business related to the public body. In addition to meetings without a quorum, Minnesota Statute Section 13D.01, Subdivision 2, lists 3 specific types of meetings that are not covered by the open meeting law. Now, what type of notice does a public body have to give before holding a meeting? For a public body's regular meetings, the only required notice is a schedule of meetings kept on file at the public body's primary offices. The law doesn't require additional advance notice or posting for regular meetings. For special meetings, which are any meetings not on the regular schedule, notice is required 3 days before the meeting. The notice must be posted on the public body's principal bulletin board or on the door of the usual meeting room and include the date, time, place, and purpose of the special meeting. For emergency meetings, which are special meetings called because of circumstances that don't allow for 3 days' notice, the public body must make a good faith effort to notify media that has requested notice. An emergency meeting might be held to deal with the aftermath of a tornado or flood. The law doesn't require posting or publishing an emergency meeting notice. Even though we're talking about open meetings, the law does require or permit some meetings to be closed to the public. The specific meetings that must be closed are in Section 13D.05, Subdivision 2. Meetings must be closed to discuss the identity of certain alleged victims and reporters, active criminal investigations and investigations of police misconduct, not public education, health, medical, welfare, or mental health data, an individual's medical records, and preliminary consideration of allegations or charges against an individual subject to the public body's authority. The law also permits public bodies to close certain meetings. The meetings that may be closed are in Sections 13D.03 and 13D.05, Subdivision 3. Meetings may be closed at the public body's discretion to discuss certain labor negotiation strategy, certain employee performance evaluations, certain property transactions and appraisals, and certain security briefings. Public bodies may also close a meeting if required by another law or when permitted by the attorney-client privilege. So, what must a public body do before closing a meeting? At an open portion of a meeting, a public body must make a statement on the record that gives the specific legal authority that permits or requires closing the meeting and describes what will be discussed at the closed meeting. Finally, it is important to point out that no government office has the authority to investigate open meeting law violations. If you decide to go to court to sue members of a public body for violating the law, the court may impose penalties. A person who intentionally violates the law is personally liable for a penalty of up to $300 that must not be paid by the public body. A person who intentionally violates the law 3 or more times involving the same public body must forfeit the right to serve on that public body. The law doesn't allow for the reversal of an action by a public body that was taken while in violation of the open meeting law. Thank you for watching this introduction to Minnesota's open meeting law. There are a number of other guidelines and requirements in the law that I didn't cover in this introduction. So please visit IPAD's website for more in-depth information, or feel free to contact us when you have specific open meeting law questions.